Good morning, everyone. Thank you so much for coming. We will have a lecture by Dame Eleanor Sharpston, the former Advocate General at the Court of Justice of the European Union. Before I give the floor to Eleanor, I will briefly introduce her. She is an English barrister. She studied economics, languages and law at King's College in Cambridge, and then she studied at Oxford University. She was called to the English bar in 1980, and this did not come easy for two reasons. She's a woman, and she wanted to do EU law in the United Kingdom. Still, in 1980, and in her own words, back then, if you were a freshly qualified woman barrister, and you said you wanted to do EU law, people looked at you as though you had green skin, antennas sticking up from your head, and you beeped when you turned corners. You were absolutely not taken seriously for a solid 3 minutes. Now, she succeeded in the bar. She was in private practice 1980 to 1987, and then again from 1990 to 2005. She became King's Counsel, Queen's Counsel back then, QC, KC now, in 1990. And her practice in English courts included some really fundamental cases, including Brown and others, Metric Marty case, or SS Stora. But still, EU law, of course, was not the flavour of the month. We are in the UK. And therefore, she also had a parallel career as a lecturer in EU law, first at the University College London, and then at her alma mater, University of Cambridge. Now, she was very popular with students, and those of you who were yesterday, you know why. Those of you who joined us this morning, you will find out very soon. Trust me, she doesn't bite. And as she told me, she's not been known for eating students alive, raw, and in public. It's actually quite the opposite. But if you look at her career, we see that Luxembourg was always the azimuth. So if you were listening to me attentively, you've noticed that there was a gap between 1987, where she left practice in the UK, and then she reappeared in 1990 again. And that was the time when she was a referendaire, a legal secretary, at the chambers of First Advocate General Slynn and then Judge Slynn. And then she herself served as the fourth and the last British Advocate General at the court from 2016 to 2020. And she delivered one of the biggest opinions of the last, not only 2030s, but actually ever. We had Zambrano on free movement of persons, the free trade agreement with Singapore, Heinrich, Slovak Bears case, and many others. Whether she was followed or not doesn't matter. These opinions were always of very high quality, very thought through, and a very good read for practitioners, for academics. She had a tendency to pull the court's tail. And a very good example was Sturgeon, where she wasn't followed, but she was very right indeed, according to many, many academics. So it's a great joy to have her lecture today about the court, the multilingual, multicultural Court of Justice, an institution that we not always think about when we think about the institutional fabric of the Union. We think about Commission, Council, political institutions. But we tend to forget that there is this very important court in Luxembourg. Eleanor, the floor is yours.
Dear Professor Adam, thank you for that very kind introduction. Dzień dobry. Good morning to you all. Let's start not with the court in Luxembourg, but let's start with a national court. I don't mind which country we talk about, but the national court is the model with which we're all familiar. Let's look at some of the components of that national court. First of all, there's a shared legal background. We're within one legal system, and the judges and the lawyers who appear before the court grew up and they trained within that single legal system. So there is therefore also a shared legal culture. There's a shared way of thinking about law. And believe me, the way that we are brought up in our own legal system and the way we think about law is for each of us the natural way of thinking about law. I trained as a barrister in the United Kingdom. It is very difficult to avoid being tainted by the idea that the way that the common law deals with a problem, with a situation, what it has by way of procedure, what it has by way of court rules, how it thinks about substantive law and concepts like how you make a contract. My friends, that is the natural way of thinking about law. It came straight down from heaven, like the tablets of stone on Mount Sinai. You know, it got written down directly from on high. This is the way you do law. And okay, there's some funny people out there called foreigners, and naturally they don't do it as well as we do. They have their own ideas, which are inferior to our ideas. I am parodying this because I do not think of law in this way, all right? To be clear, I do not think that the common law system is inherently better than, superior to, a civilian system. But it is very easy, because you train within your own legal system, it is very easy to think that that is the natural, the best, the God-given way of doing law. So in your national court, you have a shared legal culture. You also have a shared language. You are pleading to the court in the language in which the court is listening to you. Maybe you are in a member state that has 2 languages. Okay, take the example of Belgium, which has 3. You have French, you have Belgian Dutch, Flemish, and you also have a small minority who speak German. But within a particular court, naturally, you have a shared language. You don't have interpreters. You are dealing with texts and with oral advocacy that is all happening in a single language. And so the judges and the lawyers, and indeed the litigants, the people whose cases are being dealt with, they all have a lot in common. Moreover, the court is interpreting laws, obviously. Those laws are put together by legislators who likewise have essentially a shared cultural, linguistic background. There will also be a national tradition as to how you write legislation. In the United Kingdom, we have to my eyes, very strange ways of writing legislation. We write in extraordinary detail. At the same time, we try to imagine all possible situations that may arise. I'll let you into a secret, we always miss something. There is always a case that arises which falls into the gaps between what the legislator wrote down, even though the legislation is incredibly detailed. There's always something that got missed. But that's how we write it. There will also be, probably, not necessarily, but probably, there will also be an extensive tradition as to how a judge doing his or her judicial job of interpreting legislation, how they do that. How are they meant to look at the text? What are the principles they are meant to apply when interpreting the legislation? I have spent an entire morning on my feet in an English court arguing about one comma. No, really. The comma was in a particular position in the, I'm going to say, the fourth subsection of a particular section of a statute. And my opponent, my learned friend, my opponent and I were in disagreement about how you were meant to read that section based on the meaning of that comma. Why was the comma there rather than, for example, there? And we spent the entire morning, arguing about one comma. The judge listened very patiently and carefully, and he asked questions. He said, but Miss Sharpston, but you're saying the comma is there, but in section, and he named a section earlier, he said, there the comma is in a different place. I said, my lord, yes, but my lord, in my respectful submission, and then I went on to explain why the comma should be in a different place in that other section, okay? Now, if you were to do something like that in the court in Luxembourg, we would just look at you as though you were completely insane. We cannot imagine spending a morning on where you put the comma. So there is a tradition how you interpret the legislation. There is also, and this is not an exhaustive list, okay, this is just some initial thoughts. There will also, for a national court, there will be an established mechanism for the judgment to be enforced. Because in a national court, ultimately, the court has a power to enforce its judgments. It may find you in contempt of court if you don't obey the court's order. If the court's order concerns property, it may be possible to send a court officer, a bailiff in, to seize property, to make a forced order for sale. You know, many things can be done, which mean that the decision of the court has teeth, it bites. All of that is national court. Now let's ask the question, would that model of court work for the European Union? And I think the answer is fairly obvious. The answer is no. The European Union is a unique legal experiment. And I mean the word experiment. If you look into the past, usually a legal system follows the exercise of power. Someone takes over a neighbouring country. The king comes in and he annexes a particular area of territory, and after the military annexation has happened, or maybe it was a peaceful annexation, maybe there was a marriage which meant that a particular area of land got transferred and came under the sphere of influence of this new empire. At that moment, surprisingly enough, or maybe not so surprisingly, the new law comes in as the new legal system. Please note, it doesn't usually happen uniformly. Even where the new legal system comes in, often there are bits of law, like land law or like family law, which still reflect the old system. They're the type of law it's quite difficult to change. But commercial law, the law between the citizen and the administration, that type of law will reflect the new regime, but the new regime was put in place through an exercise of force or of power. EU law is simply not like that. It's a voluntary experiment. The European project has succeeded in creating a deeply integrated union of sovereign states. States who have pooled, I do say pooled, not lost their sovereignty. And initially the sharing was about matters economic. It was about the four freedoms. Think back to the Schuman Declaration, which speaks of creating Europe concrete steps that will create de facto solidarity. So it's about very practical things. It was about coal and steel in the ECSC Treaty. In the EEC Treaty, a lot of it, not all of it, but a lot of it, is about the four freedoms, about goods, about persons moving. That's fine. Over time, and driven by the common will of the member states in the face of evolving circumstances, that sharing has extended into other areas. And the other areas are much more sensitive because they are much more close to the, I'm going to use the Latin word, the imperium of the state. They're much more close to the essence of the state and the state exercising sovereign power. So they're closer to things like immigration. Think of the Dublin system. They're closer to criminal law. Think in the aftermath of 9/11, think of the European arrest warrant, which would have been unthinkable, by the way, before 9/11. Before 9/11, it was all about extradition, which is essentially political rather than legal. Think even about family law. Family law? Oh yes, family law. We have the recast Brussels 2A regulation on jurisdiction, regulation and enforcement of decisions in matrimonial matters and matters of parental responsibility, and on international child abduction. Ask the original draftsmen of the treaty whether they thought that there would be legislation on those topics. They would probably have looked at you with very wide eyes. But when you have people moving and you have marriages which are from two different families and two different nationalities, and then if sadly the family doesn't somehow work out and the partners split and one of them takes the child and disappears back to their home member state, suddenly you need to be able, almost as a logical consequence of having had free movement of persons, you need to be able to deal with the trans-border consequences of marital breakdown. And if you take the broad area of criminal law, I'll invite you to reflect on the fact that if you remove the internal borders, if you have the Schengen area and you remove the internal borders, that is, of course, great news for making more fluid the trans-border movement of goods. Yeah, I mean, it's really very, very nice that you can have goods crossing frontiers with minimal checks. It's good for ordinary, honest citizens who'd like to go on holiday with their families. How nice not to have detailed passport and customs checks when you have the car full of the wife and the kids toys, and you're trying to get to Santander and it's still 6 hours drive and the kids are getting a bit restive and you'd really like just to get across the frontier and get to your destination. It's wonderful to be able to drive through the frontier. Now let me say, not having checks at frontiers is also fabulous news for some other people. For people smugglers, for drug traffickers, for money launderers, for organised criminals of all kinds. It's really good news not to have these checks at frontiers. And so you can be a sovereign state and very interested in having your sovereignty respected, and yet decide that it would be good to have some degree of collaboration on matters like that. So the areas covered have grown, but their sensitivity has also grown, has also increased. And often the text may not be as clear as you would like, because the text will be the result of everyone, not just the British, everyone arriving in Brussels, the civil servants carrying their briefcases, and the briefcase is full of red lines. Everyone has particular points, particular issues that they're very sensitive about. And so the original draft, which may have been a model of legal draftsmanship, will get rubbed away at during the negotiations. Some of the sharp edges will be sandpapered down. Some of the definitions will be taken out because they're causing trouble. And when you put in place legislation which is a little bit ambiguous, because the ambiguity was necessary in order to achieve consensus, you are going to have a job for the court to do a little later down the line. I'm going to add to this bird's eye view that the judgments that the court hands down are going to have to work within national legal systems of bewildering diversity. I'm not going to attempt in this lecture to run through 27 national legal systems. I'm just going to say to you, look, you've still got some common law in there because you've got Ireland. You've also got bits of common law in Malta and in Cyprus. You have the main civilian tradition, or you have the French model. You also have the German model. You have the Nordic model, which is not like either of those exactly, even if you label it as being civilian. And then you have, I speak particularly standing here in Mitteleuropa, you have what has been done in the states that joined the European Union in 2004, or 2007, or 2013, where you have what happened before communism. You have the communist period. Then you have building new legal systems after communism, at which moment you will look around and you'll say, well, all right, what is a good model? Where should we go? Maybe we look at Quebec. That seems to have quite an interesting civilian code. I'm not joking. This is true. There was two systems that refer. You look at the German model. You go back into the past history of the Austro-Hungarian Empire and you find little bits there. I mean, the diversity is amazing. And yet the judgments that the Court of Justice of the European Union has to hand down, those judgments have to work within all these very, very diverse legal systems. Oh, and by the way, there isn't really an enforcement system as such. In the original version of the treaties, under what was then past history, Article 169, Commission action against member state, you got a declaration that the member state was not complying with its obligations and nothing else. All right, it tended to get enforced via the sort of, legal political horse trading that happens all the time within the EU. So if there's a judgment against me and I haven't enforced it, but I want something to happen in a new piece of legislation, you may say to me, well, you know that judgment. My tomato growers are a bit unhappy about the fact that you haven't yet done anything. So if you would like my support on this, which has got nothing to do with tomatoes, maybe you would like to enforce that earlier judgment of the court. Now there is the double infringement procedure. So yes, there is a possibility of sanction in that context. That's a relatively recent addition. There is no equivalent follow-up for the preliminary reference procedure. The court gives its decision. The case goes back to the national court, What the National Court then does with it is it is beyond the reach of the court. We hope the National Court will obviously like and respect what we put in the judgment, but we have no way of enforcing that. So, given that the national situation and the National Court, and then the situation of the European project, look so different, maybe it isn't so surprising that the Court of Justice of the European Union doesn't look much like the National Court with which I opened this lecture. So, let's begin with the inputs, with what's coming into the court. Let's start with the obvious statement: there are currently 24 languages in which something can arrive at the court. And if you add a new member state, usually that means adding a further new language. I mean, when you added Austria, no, that didn't mean a new language because Germany was already there. And although Austrian German, to my eyes, is a delightful, slightly different language, it is still basically German. And so it was not the addition of a new language when Austrian joined. But if, as I would love to think, Ukraine at some stage becomes a new member state, Slava Ukraini, Heroem Slava, if Ukraine comes as a new member state, we will obviously need to add Ukrainian. If Moldova joins, the same. If Montenegro joins, the same. Right? So, no state is going to join and say, oh, that's all right, you don't need to use my national language. Think about it. You know as well as I do that's not going to happen. So, we have a multilingual environment. We also have varied legal traditions. The legal traditions, the content of national law is going to differ, but we're also going to have different traditions. Which courts are we litigating in? Do we have a court system which has separate courts for civil and criminal law and for administrative law? Or do we have a unified system? Do we have multiple Supreme Courts at the head of each national pyramid? If we have that, then each of those national Supreme Courts will be under the obligation, under Article 267 TFEU, to make a reference unless the answer is already clair, is already obvious. If you take Germany, that means that you have half a dozen courts that may be under that obligation, for example. So which courts? What are going to be the procedural rules? A lot of issues now come up relating to procedure and access to the court, and whether the application of national rules gets in the way of the effective exercise of rights under EU law. And of course, there are all the issues about remedies. If my right is infringed, do I actually get an effective remedy which puts that infringement to an end, which repairs the damage that was done? The remedies are going to be different in all the national systems. The references are going to come in from all member states' national courts. In the newer member states, there is maybe less understanding of EU law as yet than in some of the older member states. I say that, I am going to say, from my experience of pleading in the United Kingdom, that sometimes I found myself having to explain the basics of EU Law 101, to my judge, even in a member state that had been a member state for some time. So I am not being rude about the newer member states. But sometimes it's very natural that the national judge will want to ask a question. By the way, the way in which the judge asks the question, how he or she writes the order for reference, that will also depend on the national tradition. Again, to give an example, if you read a French order for reference and you read a German order for reference, both from very old, established, original member states, they're not written in the same way. The style of writing, how much goes in, what order the court deals with it, where they put the questions, at the front, at the end, how much detail they give you, it just is different. So there's that. The texts of the legislation, the EU legislation, whose interpretation has given rise to the reference, those texts are going to exist in all the different languages, and they're going to be equally valid in all the languages. Now, we probably know or can guess that when the legislator was debating the text of a new regulation, probably they were not debating the text in Lithuanian. It's more likely that they were looking and having discussions about the text in French or English or maybe German, but the text in Lithuanian is as valid as a matter of law as the text in the language of drafting. Another input, an important input, is that what is coming in from the parties is also multilingual. The written pleadings and the oral pleadings are going to be multilingual. Actually, the written pleadings are easier because when you have a written pleading, you have time. You can give the written pleading in Latvian, Estonian, Portuguese, Greek, whatever. You can give that to the court's lawyer linguists for translation into the working language of the court. And written translation, you have time to check things. When you have a hearing, this is a sophisticated version of the Tower of Babel. Let me make an imaginary example for you. Let us suppose that we have a reference from a Finnish national court. So the starting language is Finnish. Starting point is Finnish. We then have written observations from Denmark, Sweden, Spain, and Slovakia. All right. I'm making a checklist of the example I give you so I don't lose the language along the route. We have Finnish, Danish, Swedish, Spanish, and Slovak. The court decides this case needs a hearing. At that moment, the Danes decide that they're not going to come, but the Portuguese and the Greek governments decide they'd like to be there. They've woken up, they realise that actually they have a particular interest in this case. So we're going to have a hearing before a chamber of 5 judges with a Romanian juge rapporteur and a Croatian advocate general. Okay? So at the hearing, we've got Finnish, Swedish, Spanish, Slovak, Portuguese, and Greek. Reporting judge, Romanian, advocate general, Croatian. Now let me ask the question, it's a rhetorical question, what do you think the chances are that the Greek interpreter knows Finnish? Think about that for a minute. I can think of only one possible reason why the Greek interpreter would know Finnish, and that would be if his Greek mother happened to have married a Finnish father. But except for that perhaps rare coincidence, there is no way that the Greek interpreter is going to have learnt Finnish as part of his professional training. Rationally, the Greek interpreter will have learnt French, English, maybe German, but not Finnish. So that is going to mean that anything that is said in Finnish, which needs to get into Greek, and it has to get into Greek because the Greek government has to know what is being said by the parties in Finnish, that is going to go through a relay system. So that is going to go from Finnish into either German or English probably, and then it's going to go into Greek. Think about that for a minute. What is that going to do to the amount of understanding, to the percentage of material that gets across? Well, I'll tell you, that depends very much, not actually on the quality of the interpreter. The interpreters are very good, and they prepare very thoroughly. It's going to depend a great deal on the advocate. If the advocate is intelligent and realizes that everything is happening through language, the advocate will speak slowly. The advocate will use short sentences. The advocate will not choose to use funny expressions in their mother tongue, which are proverbial or jokes. The advocate will pick words for the pleading that are capable of instant comprehension and instant interpretation. Now let me let you into a small secret. Not all advocates do that. If, on the contrary, the advocate who is nervous because they have never before pleaded in front of the court, if they turn up with a very detailed written text, which is written the same way as you write, which is not the same way as you speak, because a written text often has a much more complicated sentence structure with lots of sub-clauses, whereas oral speech doesn't work like that. If your advocate turns up with this text, and the text is actually rather long, but he knows that he has got 15 minutes, and he forgets to adjust the microphones so they're not pointing directly at him, and then he puts his head down and he reads the text at 200 kilometers an hour so that the text happens within the time that he has been allocated. What do you think is the percentage of that text that is going to make its way through from Finnish via German into Greek? Answers on a postcard, please. So, you've got lots of diversity and you've got some natural barriers, some natural handicaps to the court working. Now let's have a look at the court. How is the court going to be structured? How is it going to have to be structured in order to cope, in order to deal with what is coming in through its door? Well, for a start, we are going to need to have every member state represented in the composition of the court, a judge from every member state, because otherwise there will be no legitimacy for the court's rulings at national level. It will just be an interfering foreign court. By the way, I know the Brexiteers said that anyway. Okay, I know, but they said it without justification. If you don't have your judge on the court, it is an interfering foreign court. And by the way, it's interesting that the Strasbourg court, the Human Rights Court, and the court in Luxembourg operate differently. The Strasbourg court, you always have the judge of the nationality of the case is one of the members of the court. In Luxembourg, you don't have that rule, so you can very easily have a decision, including a decision of the Grand Chamber, in which, quotes, your judge, close quotes, is not sitting. But your judge is a member of the court. And when the case goes through the general meeting of the court, if there is something particular that the court needs to be aware of, the judge is perfectly entitled very gently to point it out. So that I'm not going to influence the outcome of the case, obviously, but you should be aware that. So there is a sort of input from the national legal system, from the national tradition that happens there. So you're going to have that. You are also going to bear in mind, perhaps, that individual members of the court, judges, advocates general, they're individuals, all right? We each come to exercise functions within the court from our own background, and the backgrounds are very varied. Sometimes it's the person who helped negotiate accession for that member state. Sometimes it's somebody who was previously a judge on the Human Rights Court in Strasbourg. Sometimes it's someone who was within the legal service of the council or the commission at a high level. Sometimes they've come across from a national constitutional court or a national Supreme Court. Sometimes they're an academic, a distinguished academic. Sometimes they're an academic practitioner. That was true of Advocate General Francis Jacobs. It was also true of myself when I went to the court. So varied individual backgrounds that are going to come into this story. And please note, there are lots of really important support staff. We always talk about the court as though the members sit on some cloud of glory and dispense justice. Well, actually, the court could not possibly function without the referendaires who work with the individual members, without the translation division, without the interpretation division, without what is known by the acronym Recherche et Doc, Research and Documentation, the court's internal research division, without having a registry that is subdivided into linguistic units so that the court can interact with national courts and national lawyers in their languages. All of that infrastructure is deeply important to the court being able to work. And all of it creates consequences in the dynamic of how the court operates. So what is the impact on working methods and methods of interpreting legal texts? Well, to start with, you have to have one internal, unofficial working language, not official. There is no official working language, but unofficially, the working language is French. French, because it was French at the beginning, and the court hasn't changed. The other institutions moved across to English as the common working language. The court still works in French. Next impact is the ubiquitous relevance of language and translation. The court's translation division often uses the picture of an hourglass to explain what is going on. So things come into the court in all the languages, the big bit of the hourglass at the top. They then get put down through a really narrow little neck, which is French, because everything comes from the original languages down through French. Inside the court, it gets dealt with essentially in French. And then the bottom bit of the hourglass, the output of the court, the opinions of the advocates general, where these exist, but also, and most importantly, the judgments of the court, all of those get translated into all the languages. Picture the hourglass. That's how it works. Next observation is the technique of interpretation, which, as you probably know, is teleological, it's purposive, it's not literal. I made a reference earlier to the argument in the English court about the comma. You can't have that argument in the court in Luxembourg, because if you take the texts in even 6 languages, and you look at Article 27, subparagraph 2, and you look for the comma, dear friends, there will not be a comma in the same place in those 6 languages. One text may have 3 commas, one text may have no commas. This is not going to work. It's not even going to work on the basis of looking at the words rather than the punctuation, because although EU texts, legislative texts, are subject to what is delightfully called a process of linguistic toiletage, toileting, tidying up, nevertheless, things slip through. I can think of at least one case I handled, the Emirates Airlines case, where the whole reason why the national court made the reference, a German national court, was that in the German text of the air passengers regulation, it was possible to read the regulation as applying to both an outbound and a return flight if that happened from a community airport. Whereas in the other parts of the regulation and in the other language versions, it was clear that if you had a flight going out from a community airport, the regulation applied both to a community airline and a third country airline, like Emirates Airlines. But if you had an inbound flight, it only applied to a community airline. But that distinction was not clear from the German text. And so the German court made a reference. And a chamber of 5 judges and an advocate general both spent a long time unpicking the different language versions in order to arrive at the conclusion that no, when you have a return flight, you look separately at the outbound flight and the inbound flight. I'm going to go from there to the personality and the background and the different jobs of the 2 members of the court who are responsible for each case. Each case has a reporting judge. Each case has an advocate general. Please note, not just the cases where there is an opinion, each case. Those 2 members of the court are like minders. They are responsible for seeing the case through the system. But of course, they are individuals. They come with their own background. And their background will affect, will colour their reading of the case. Perhaps crucially, and most difficult to deal with, they will have made assumptions. We all make assumptions. All lawyers make assumptions based on what is natural in their legal system. And if 2 lawyers from the same legal system talk to each other, this doesn't matter, because you have a shared background and you have shared assumptions. So you never have to make the assumptions explicit, because you made the same assumptions instinctively. If you have 2 lawyers from different backgrounds, they may make different assumptions. One may assume black and the other may assume white, or at the very least, different shades of grey, no pun intended. So, they will have different views of the case. Sometimes you say to yourself, I wonder what on earth the problem is with this case. My reporting judge, he's normally such a reasonable person. He seems to have a completely bizarre view of this case. And he is saying the same about me. Yeah? And where that happens, that is usually because you have both made assumptions, and unless you manage to realize that that's the problem and to make the assumptions explicit, you are not going to get a long way forward with the case. Now, the different background and the different personality is also going to impact the case in terms of the approach you take, in terms of whether you're prepared to be innovative, whether you have new ideas. Traditionally, an advocate general has more space than a reporting judge, and that is partly a natural consequence of the different jobs. If it's a different case from anything that's happened before, and if it's difficult, the Advocate General's opinion provides more detail, more analysis, more exposition, but also more space for trying out ideas, for making suggestions, for looking at possible ways of dealing with the case and then recommending one of those paths. And importantly, it's a solo effort by the Advocate General and their team. Please note their team, not by the AG on their own, the AG and the AG's team. But essentially that is one person speaking, one person giving their opinion of how they think the court should solve the case. The judgment is not a solo effort. The judgment is the product of multiple minds and consensus building. You have to get together and compromise to arrive at a single text. Also, please note that unlike the American Supreme Court, you select the reporting judge at the beginning of the story. In the American Supreme Court, once you have heard the case and you're going to decide it, you select members of the court to write for the majority, and if there's going to be one, to write for the minority. And so the draftsman is writing their position. Because the reporting judge at the Court of Justice of the European Union is selected at the beginning of the story like the Advocate General, it is entirely possible to have the reporting judge in a minority. The reporting judge thinks the answer should be X. He is convinced the answer should be X. He's in a 5-judge chamber. One member of the chamber agrees with him, but unfortunately 3 members of the chamber do not agree with him. He is still trying to draft the judgment, a judgment which he thinks is, quotes, going the wrong way, close quotes. So, human nature being what it is, he is probably going to try to frame the judgment very narrowly in order to limit, as he sees it, to limit the damage that the judgment is doing because it's going the wrong way. And also, in order to get a collective consensus text, you're going to have to take out some passages which not everyone agrees with. I will let you into a secret without breaking my oath of office, not to divulge what goes on in the deliberate. I will just let you into a fairly obvious secret. It is much easier to take out text than to write text to replace that text. Taking out text involves pressing the delete button on the keyboard. Really simple. Writing new text to replace that text is not so simple at all. And I am sure that you will have seen in some judgments of the court, you can see the text goes 1, 2, 3, 5, 6, 7, 11, 12, 13. And you think, hang on, wait a minute. Maybe I need more coffee. Maybe I, went to sleep when I was reading. Let me try again. And you go back and you think, no, really there is a gap in the logic there. You can see the scissors, electronic scissors that went across the page. That is often where it would have been easier to have had a different answer, or there wasn't really time to put in a new text. Maybe the Advocate General, by the way, went the other way. If you have a case where the Advocate General goes one way and the reporting judge and the court go the other way, and there is a gap in the reasoning in the judgment, sometimes that's a little hint to you that this was a difficult case for the court to decide. I'm going to say a final thing here, which is that the authority of the court, in terms of its enforcement power, the authority of the court lies only in the quality of its output. It does not have the officials to send in to enforce its judgment. The court lives by the quality of what it writes. And its aim, among all this diversity that I have been highlighting, its aim is unity. Its aim is to give a single ruling that creates uniform application of EU law in all member states, to give a single ruling that can be applied by the national courts, each within its own national legal system. Okay, does it work? Does it work? Obviously not always, but I will ask the rhetorical question, do any Supreme Court's judgments always work? Think about any national legal system you care to examine. Can you truly say that every last single judgment of the Supreme Court works, was correct, was obviously clear and rational and consistent? Can you say that? I won't say that about English law. But I don't think you could say that about another legal system either. A surprising proportion of the time, maybe very surprising given everything I've been talking about, a surprising proportion of the time, actually, yes, this does work. And what the court decides helps to consolidate, to unify EU law, to make it more comprehensible, to make it work more effectively. And so I will conclude with a thought before I invite you to ask questions about all the bits that I didn't cover properly. I will conclude with this thought. Every time we add another member state, and we're going to be adding more member states, I'm happy to say. Every time we add another member state, we add further diversity. We add further complexity. We also add further richness to EU law and to the court. Diversity is a challenge. It is also a treasure house. And with that, I will finish, and I will invite your questions. Thank you very much.
Yes. Thank you very much, Eleanor, for this excellent, very interesting lecture. When you were talking about scissors and judges cutting the judgment, it reminded me, obviously, the Zambrano case, which those of you who will be taking Catherine Barnard's course, trust me, you will have that case. Now read the opinion of Advocate General, and then read the judgment. I remember when the opinion came out, it was an absolutely novel issue about EU citizenship, its nature, its scope. And many of us were reading the opinion, not in one reading, because it was a very long opinion, very thorough, And then obviously, once we saw on the website of the court that the judgment is coming, my colleagues at the law school were texting each other, saying, that's going to be interesting. What's going to happen? And then we got the judgment, which was 7 paragraphs long. I mean, 25 or 30 paragraphs long, but the actual reasoning was 7 paragraphs. And we were sitting on one floor in our offices, reading as it came out, and then opening the doors rather quickly, saying, have they missed something? Did they publish actually the judgment? Because, yes, there are 7 paragraphs which look like reasoning. There's no reasoning whatsoever. I think that's the extreme case where obviously we don't know what happened during the délibéré, but it's obvious that something was very, very wrong, that the judges, was a Grand Chamber case, could not agree on the text, and at the same time they knew that it had to go out. I mean, it had to be delivered. And obviously that created a huge problem for national courts. I had at the time a colleague who was an immigration judge, and every time he would pass me on the hallway, he would look at me with that sort of, you should be guilty, Zambrano. It's not my fault, but that's an extreme case, isn't it? Now, we're going to take questions from you, obviously. There's a microphone over there, but I will abuse my dominant position. I'll ask the first question. You've mentioned national lawyers coming to the court and pleading, obviously, pleading in their own language, bringing their own culture with them, wearing traditional gowns as you would wear in the national court. And you've experienced, back when you were referendaire for Sir Gordon Slynn, a case where an English barrister decided to be very clever, forgot about interpreters, and that an idiom in one language means absolutely nothing in the other. Can you tell us that story?
So this is a case about milk quotas, a case that was referred from an English court. So we have English barristers pleading, and we had Sir Gordon Slynn as the reporting judge. We've had the main pleading. Now we have question and answer. Question from Sir Gordon, answer from counsel, question from Sir Gordon, answer. And I swear that very early on in this exchange, question and answer, both of them had forgotten they were in Luxembourg. It is as though they were back in London in the High Court with the judge asking questions. And so, nice exchange, information, that was fine.
And
So
it all goes through interpreters.
of course this is all going through the interpreters, because the other members of the court are not English mother tongue, and, naturally the interpreters are doing their job. And Sir Gordon asks a final question, and counsel answers the question, and then counsel thinks he's going to be clever. Or rather, he thinks, I will do what I would do in the English court. I will just put something at the end of the pleading which sort of makes the point even better and shows what a clever lawyer I am. I'm sorry to tell you, barristers tend to show off. All right? Professional deformation on our part. So he gives the answer, and then he says, indeed, my lord, one might say that what is sauce for the goose is sauce for the gander, my lord. And Sir Gordon smiles. This is an old saying in English. Goose, gander, both sexes of goose. If the sauce works for the male goose, it also works for the female goose. That's fine, but I just explained it to you, yeah? There is absolute silence from the interpreters. And you can see them behind the glass screens. You can see them looking at each other. What the was that? And all the other members of the court, obviously, have their earpieces in position, and they are all sitting there very politely waiting for the interpreters to tell them what is the last thing that the lawyer said. The silence seems to go on forever. It cannot really have gone on for that long, but it felt like an eternity. The situation was saved by the French interpreter. Now, French is kind of the senior language at the court because it's the internal working language, and the interpreter was a very, very senior, very, very experienced interpreter. And she was not amused. She leant forward, she punched the button on her microphone. You could see the gesture. And then, in a voice that was so cold that it was about 30 degrees below absolute zero, she said, I give it you first in French and then I translate. Il vient de raconter une blague sur la volaille. He has just told a joke about poultry. Now, it was a brilliant thing to say because, of course, the reaction in the court was the reaction you have just given me. There was a polite laugh, right, which is fine. The lawyer thought, okay, you know, it took the interpreters, poor inferior people who speak other languages, it took the interpreters a moment or two to understand my brilliant English wit, but it's all right, they interpreted. The rest of us were laughing at the lawyer because we were thinking, what an idiot, what a muppet. How can he not have realized that this really old saying in English, it is not current English. If you went into the street in London and said, what is sauce for the goose is sauce for the gander, people would probably these days just look at you. It is not something that you say currently in modern English, right? And also think about it. You are an interpreter. You are dealing with a case about milk. Why should you expect that suddenly you're going to get fowl, you're going to get poultry come into the story, and that you are going to have to remember that in English, the word for a male goose and the word for a female goose are two different words? I mean, come on.
I'll test it on my English students now. Let's see if they know it. Right, your turn, guys. Please use that microphone over there. Ooh. Flip a coin. We'll start with you, please.
Thank you, Dame Sharpston, for your lecture today. My name is Alva. I'm from Ireland. And my question comes from, I think, in the context of the last few years in Europe and the way that the geopolitical policy of the EU has changed a lot, it's interesting to ask the question of whether that's reflected in the Court of Justice. And I was wondering if, in that context, as an Advocate General, when you were delivering your opinions, to what extent you took into account European policy rather than legislation and the broader political context of the time. Thank you.
Thank you for the question. Do we have a 3-hour slot we can schedule for answering it now? No, thank you very much for the question. I think the very shorthand answer to that would be that the court is on a plateau in Kirchberg in Luxembourg, but it doesn't live in an ivory tower. I mean, it is aware of the fact that there are political currents out there, that there is such a thing as policy. At the same time, it is a court of justice, and its job is to interpret what it has in front of it in terms of a legal text. Now, to some extent, those two things cross over, because when you're reading EU legislation, unlike when you're reading an English statute, you don't begin with Article 1. You begin with the legal base, and you begin with the recitals. And when you look at the legal base, and when you look at the recitals, you do get quite a strong feeling for what is going on in policy terms behind the text, the legal text that you are about to read. And so when you come to looking at Article 1, Article 2, Article 3, you look at those against the background of what you've already seen in the recitals. So to that extent, you are inevitably looking at law in its policy, political context, but you are still dealing with the text that's in front of you. And this becomes particularly acute. I mentioned earlier areas of immigration law, criminal law, for example. Now, those areas of the area of freedom, security, and justice, the AFSJ, they are very sensitive areas, and there is a tendency to put into the recitals a recital to make everyone happy. So you want me to emphasize this, I write in a recital. You'd like me to write in something else because a different aspect seems to be important to you. So I write in a recital to make you happy. So sometimes I end up with slightly contradictory recitals, and sometimes I end up with a text that is a compromise text and that doesn't have as much clarity as a pure lawyer would like, because it has the ambiguity that was necessary to ensure its adoption. It managed to get adopted precisely because the text was capable of bearing 3 or 4 meanings. That's how it got through. When you see a text that looks like that, you are looking at a grand chamber case about 5 years down the line. Because that's about how long it would take for some intelligent lawyer in practice to pick up the text, looking at it on behalf of his client or her client, and they'll say, you know, I think you can read Article 17 in a way that's helpful. And then the other side of the case, probably the state, in my example here, the advocate for the state will say, it can't possibly mean that, meaning we didn't mean it to mean that, right? When you have that situation and you have 2 lawyers saying to the national court, you don't need to make a reference, it's absolutely clear in my favor, don't listen to what he's saying, and vice versa. If you're a sensible national judge, you will make a reference. And at that moment, all bets are off, because the court is going to have to pick one meaning. Once it's gone to the court for interpretation, you cannot have coexisting 3 or 4 different meanings. The Advocate General is going to have to go first, look at the drafting history, looking at the legislative history, looking at all the implications, looking at the arguments that have been put, and then making a recommendation. I recommend to the court that the court should decide in this way, and then the court is going to have to chew it over, and the court is going to have to make up its mind on one reading. So it's a bit like, I guess the answer I've given you is a bit like the saying of Bismarck, that if you're fond of sausages and you're fond of law, you maybe don't want to know too closely how they're made. But actually, that is the real issue that falls to be decided, and that's actually what happens.
Right. And then the gentleman over there. And as you're walking to the microphone, I mean, if the court decides to fudge it, this will hit back, because it will get more references from national courts saying, what did you mean in that particular case?
Absolutely. Please.
Oh, thank you. Thank you very much. I echo what Alva mentioned. This has been so insightful. My name is Nada. I'm from Egypt. I was wondering, since we're talking about languages, we were talking about like English, Irish, etc. But I was wondering about the technical language and how you're navigating it, because I know that you worked on several cases ranging from environmental law, things concerning migration. So I was wondering how you tackle the technical terms that are in different aspects of like the different cases and try to prepare for that to make like a profound outcome when it comes to your opinion as an advocate general?
That's a very acute question. Sometimes you try to avoid the problem. I'm going to tell you I did exactly that in one case in which I gave an opinion between when the UK left on the 31st of January 2020 and when I left the court on the 10th of September 2020. Because yes, I went on working during that period and I went on writing opinions. One of the opinions that I issued was in respect of, it was part of the Dieselgate scandal, the scandal of a company falsifying the tests in respect of emissions. And already when I say that, you can understand that there must have been a lot of technical terms. There were a vast number of technical terms, and there was a technical report from an expert who'd given evidence to the National Court, and it was absolutely stuffed with technical terms all about how diesel engines work and all about the devices to control emission, and how if you adjust the device you can falsify the test, and then when the car is actually running on the road it produces a different level of emissions. And I cheated. I cheated because the reference had come from a French court. And so I wrote in French. I was working with one of my referendaires, who was French mother tongue. I myself, I'm not bilingual. In my own terms, I'm not bilingual, but I'm very comfortable in French. And we just looked at each other and we said, no way are we going to try to write this in English. We're going to write this in French. And our nice translators, who after all had already done all the research to translate the order for reference into English, our nice translators are going to do the necessary in order to make sure that this text exists in English. So, I mean, sometimes you can just cheat. Where you can't cheat, and most of the time I didn't cheat, I knew I was working with a guillotine over the back of my neck, and I knew that the guillotine was going to come down fairly shortly. Where you don't cheat, remember that you have the legislation exists in all the languages. So what you do is you take the legislation in the language that you want to write in, you keep a careful eye open, looking at least one other language to try to make sure that you have a sort of safety check on the text that you're reading and using to give you the vocabulary to write. You hope that you managed in the course of studying the file, you hope that you managed to take it out of technical speak into something that people can understand. And partly you test that, if you have a hearing, you test that at the hearing. You say, for example, at paragraphs 18 to 24 of your written observations, you make a rather lengthy argument. Let me see if I have summarized it correctly. Essentially, what you are saying is, and then you give a summary not in gobbledygook, not in incomprehensible technical speak, but you give a summary in plain language of what that argument is. And then you look at the lawyer and you say, is that a fair summary of your argument?
Right, next question, please.
Hello, Hello, thank you very much for your very interesting presentation. I'm Franciszek from Poland, and forgive me to asking a question not directly connected with European Court of Justice, but as a young lawyer, I would like to address the more mature and distinguished one about the current international legal situation. I don't know whether you are aware of the recent event in Poland, but yesterday our government adopted a statement saying that they will ignore an order of International Criminal Court regarding Netanyahu without providing any legal justification of that fact. And it will be not an overstatement if I say that yesterday I was devastated because of this information, because in this unsecure, unprevisible world, another fundament of our international order is trembling, because right now, unpopulistic, democratic government of big European countries is saying that we'll ignore yet another order of international institution. And where do we go from there, from here? To which extent are we still able to preserve our current international legal order if such things are happening over and over regarding almost every single institution of our legal system?
One of the things that you learn through the passage of years is not to give an instant reaction to something you haven't read. All right, so I have not read the statement from the Polish government. I am going to make an educated guess that this could perhaps be in relation to the ceremonies to mark the 80th anniversary of the liberation of Auschwitz. It's merely an educated guess, but I see you nod. And given that that educated guess is correct, the second educated guess might be that this was in relation to the arrest warrant issued by the International Criminal Court in respect of the Israeli Prime Minister. Now, I will make a passing comment rather than a definitive observation. The passing comment is that there is something a little bit strange about that arrest warrant, because Israel lodged objections at the moment when the special prosecutor, Ephraim Khan, applied to the chamber of the ICC for the arrest warrant to be issued. Israel raised, unsurprisingly, some objections. One of the objections was to the jurisdiction, because Israel is not signed up to the ICC, and Palestine in international law is not a state. Now, whatever you think of the validity or otherwise of those two arguments, it would normally be the case that where there is an objection to jurisdiction, you deal with that objection first. Because if you don't have jurisdiction to do what you've been asked to do, you shouldn't do it. All right? So kind of basic principles of how courts operate mean that if there's a challenge to jurisdiction or if there's a challenge to admissibility, you usually deal with that first. Sometimes with admissibility, you attach it to the substance, but challenges to jurisdiction, normally you deal with first. Now, for whatever reason, and I have no idea what the reasoning was, I have not been following this, but for whatever reason, the chamber of the International Criminal Court that endorsed the issuing of the arrest warrant did not do that. They noted there was the challenge to jurisdiction, but they said, we will deal with that if it ever matters. We will deal with it on the substance. The substance, presumably, is if somebody actually arrests the Israeli Prime Minister, right? Now, when a court does something like that, that is actually unfortunate already in general terms for the rule of law. And it's unfortunate because it inevitably raises question marks as to whether the court is behaving entirely objectively, impartially, judicially, or whether it is allowing itself to be influenced by political considerations. Now, I'm going to stop what I'm saying there because I do not know enough background. I haven't been following it, and it would be improper for me, as somebody who used to be someone holding fairly high judicial office, it would be improper for me to speculate against the background of non-knowledge further. I am assuming that thought went into what was said in Poland. I do not know enough background to comment further, but what I have said is entitled, if I say, is intended to highlight the real need for international courts, international judicial bodies, to be super, super careful, to be seen to behave judicially and only judicially. Because the start of a downward slope, the slope doesn't start here, the slope starts up there. And the start of the slope is if an international court, whether that be the ICC or the ICJ or the Court of Justice, does something where people can point at it and say, whoa, that looks political, right? That is the start of the problem.
Next question, and then.
Thank you, Dam Sharpston, for another brilliant lecture today. I'm Prodromos from Greece. There is a debate, a question that we've discussed in the first semester in many classes in EU law, EU institutions, and we've read in many articles about whether there is a pro-EU, pro-European bias in the court in Luxembourg. So I would like to listen to your own personal view on the topic, if there is such a bias. Seeing also you already yesterday on how passionate you are about the EU, and probably more judges and advocate generals share their views. So I'm wondering, on your personal experience having been for so many years in Luxembourg, whether such a bias exists, and whether, if it does, assuming it does, whether this should be kind of limited or controlled in a way, and what that would be. Thank you very much.
Thank you for the question. Or rather the two questions, but your second question is dependent on the answer to the first question being yes. The answer to the first question is no. During the 14 and a half years that I served in the court in Luxembourg, well, either I am a very unobservant person, all right, or alternatively, what I'm about to say to you is correct. I never came across a secret project for deeper European integration. When I joined the court, they did not show me a secret document saying, this is the mission statement. Now read it and then eat the document because this is meant to be secret, okay? My experience of being at the court was that week by week, we sat down at the general meeting of the court, at the Réunion Générale, and we discussed housekeeping, we discussed how each case would go through the court system, what chamber it would go to, whether there would be a hearing, whether we needed an Advocate General's opinion. As I listened to that discussion, the position of my colleagues on EU law interpretation, on whether we want closer union or we want more sovereign member states, gradually the position of my colleagues, if you like, kind of emerged, not without anyone, not by anyone saying, standing there and hammering the table and saying, you know, I believe this, I believe that, but just in the way that people commented on particular cases, you began to get a feeling for whether they were more or less integrationist, whether they were more or more federalist or less federalist. And truly, within the court, there were very different shades of opinion. One of the great ironies of Brexit is that after the president of the court, I was probably the member of the court who was the most passionately pro-European, pro-federalist, pro-European project in terms of everything that I wrote as an Advocate General, in terms of what I taught as an academic before I went to the court. I was probably, you know, the person, if you were to cut me open, you would probably read the words European project, you know, written all the way through. Which makes it the more ironic that as a consequence of Brexit, I was evicted from the court. All right? I mean, that is actually one of the ironies of history. But I really can assure you that among those serving at the court, there are very different shades of opinion. I can also assure you that actually the court is a working court, all right? What does a court care about? The court cares about getting through its caseload. So you don't sit down and say, ooh, that would be a good case to make a big statement, you know, about this or that aspect. You think, okay, we've got that case. That looks a bit hot, a bit difficult, a bit awkward. We're going to have to be careful what we say there. On the one hand, we want to get a clear message that the text must have meaning. On the other hand, we can see this is difficult and it's politically hot. So we're probably going to try to say as little as we can, consistent with deciding the case. You don't try to make a big statement about an entire area of law. You try to make the statement of principle, which serves as the springboard for the decision, and then you apply that to the situation of the case. And often, this is one of the differences between an Advocate General's opinion and the judgment. Often, the Advocate General's opinion will take a wider look at the surrounding territory before recommending a particular course of action. And the judgment will try very hard just to go for what is needed to decide this case.
Right, I'm fully aware that we have the fundamental right to have a lunch. So one more question and then we finish. Thank you.
That's Article 92 of the European Convention of Human Rights.
In fact, I had 3 questions, but I'll try to be very
ask
fast.
The three. Ask the 3.
I'll try to be very, very fast, and I will settle for easy answers. I am Claudia. I come from Portugal. Thank you very much for your presentation, both yesterday and today. Very insightful. The questions I have are mostly regarding the practical explanations you made regarding the functioning of the court that you made just there in your speech. The first one is regarding if advocates, when they come to the court, they bring a text, and when they bring their texts and they read them like this, and no one can and it's hard to translate these texts. If these texts, like in the European Parliament, because sometimes it happens, if these texts can be sent to the interpreters beforehand, or if that cannot happen because, in fact, it's about privacy, data, etc. So this is my first question, if these texts can be sent for interpretation earlier to ease the process. The second question is regarding the languages that are not commonly used, even though they are official languages of countries and the EU, of course. In my mind, I have the examples of Irish and Luxembourgish, because, of course, they are official languages in 2 countries and also part of the EU. But in Ireland, people can go around with English, and English can be used in the court, and the same goes for Luxembourgish. People go around with German and French, and both are easily spoken also in the court. To what extent, in the example you gave, in which 5 languages need to be translated from Finnish to Greek and etc., and go into German in between, to which extent interpreters interpreting in Irish and Luxembourgish also need to be called to these meetings if the Irish government and Luxembourgish government are involved? The last question is regarding the last bit that you said in your speech regarding diversity of EU law. I would like to hear your insight as a British person when you had in 2020 to leave the court because of Brexit. We all know that, in fact, the EU law lost a lot regarding the exit of also British law from the legal system. We are talking, for example, of legal system that has no written constitution, for example. So to your knowledge, to your opinion, what was the biggest loss that we lost when Brexit happened and when the British legal system was taken away from the EU law? Thank you very much.
Muito obrigado para as suas perguntas.
De nada. Obrigada eu.
Okay, in the thought of you scheduling an immediate follow-up session, let me try to answer those 3 questions as succinctly as I can. The first question was about written texts for the interpreters. Lawyers can send a written text to the interpreters in advance. Hint, lawyers often do things at the last moment. So even though you can do that, the text very often arrives the evening before the hearing for the interpreters, or maybe it arrives in the morning, 10 minutes before the hearing starts. And the text may very well be the wrong length for what is going to be the speaking time. There is an absolutely rigid wall between the interpreters and the members of the court. So a text that is given to the interpreters will not be given to the court. It stays inside the interpreter's booth. That is partly in the interests of the lawyer, because the lawyer may need to modify what they say in the light of what other people are saying. And they might not want what was in the written text to go to the court. So the text stops inside the interpreter's booth. The interpreters will interpret what is said orally, not what is on the piece of paper. Obviously, if you get the piece of paper well in advance, that is going to help. But they will interpret what they hear. Your second question was specifically Irish and Luxembourgish. Now, there's a difference there, because Irish is an official language. Indeed, it's the first language of Ireland, according to the Constitution. Luxembourgish is an official language within Luxembourg, but it's not the official language of Luxembourg for EU purposes. For EU purposes, Luxembourg has both French and German, which are internal languages in Luxembourg and which are both official languages. So, whereas if you speak Irish in the court, that's fine. You can't speak Luxembourgish. I can't resist saying that in a case called Gerna, which is about a Dutch teacher of art who was working in Dublin and who failed to pass the Irish language test and therefore wasn't established on the post. That splendid friend of mine and splendid Irish colleague, Karen Banks, turned up to plead the case on behalf of the Commission. And Karen decided she was going to quote from a wonderful poem in Irish about the Cliffs of Moher. She very thoughtfully provided a translation of the Irish into English, which she gave to the interpreters. We will never know whether what happened was by accident or design, but the text in English didn't reach the English interpreters. And so Karen was pleading in English, and then at the critical moment in her pleading, she burst into Irish, and all the other interpreters happily went on interpreting because they had a translation. And the English booth just sat there saying, what the hell is going on? Eventually, I mean, they picked it up from the French, and then they translated back into English and so on. But it was a very lovely moment. Your final question, can you, if I say, can you reformulate that question as to exactly what you're asking me? Because I'm not entirely sure I got it, or maybe my memory is just not operating correctly. Please, if you would. Please.
Okay, I will reformulate it easier, in an easy way. You talked about the diversity of EU law inside the court. EU law comes from all the 27 put together. That's at least from what I understood from the beginning of your speech. We lost the 28th.
Ah, sorry. Now yeah. What single thing
Yes.
did we lose when the UK exited?
In your opinion, exactly what was the biggest loss for us as a total of
right?
This part of legislation?
Thank you. Thank you for that, because I wasn't certain whether we were talking about law or legal culture or British contribution to the EU project, or, because these are somewhat distinct things. In terms of law, In terms of law, we still have a common law input because, of course, we have Ireland. Although Ireland has the good sense to have a written constitution which alters the way that Ireland and Irish common law operate. But there is a strand of the common law tradition which is still alive and well, which is still there. In terms of legal culture, again, that is, I think, covered by Ireland. By the way, Malta also has some aspects which are distinctly common law. Those are the bits of Malta that aren't Italian. I mean, that's a whole separate story in itself. In terms of the overall contribution, there was a degree of pragmatism of let's not worry too much about ideology, let's try and think of a practical way forward, which was a hallmark of a particular element of the, I'm going to say, the British civil service tradition, right? Which is managing to find ways of making things workable. The ways of making things workable are sometimes intellectually not entirely pure, right? But often they work. They often produce a solution which can in fact be implemented even if you can't analyze it perfectly in Descartesian terms, and somehow it's all right because it works. And I think it is one of the ultimate ironies of Brexit. There are many ironies of Brexit. But one of the ultimate ironies of Brexit was that Brexit was essentially the triumph of ideology over pragmatism. And that was very un-British.
Right. Thank you very much, Eleanor, for coming over to Nataline to have the 2 sessions for us. I hope you've enjoyed it. And I should like to ask you for a round of applause for Eleanor for this lecture. Thank you.